to stick around until the end. You do not want to miss when I discuss item number 6. It's a crime that's often committed, and a lot of times people don't think it's a big deal. But the truth is, it can land you with prison time, up to 10 years in jail, and it carries a fine of up to $5,000. I'm going to start by talking about Louisiana Revised Statute 1498, operating a vehicle while intoxicated. So let's look at this together. This, I would say, is the most common of the 6 driving offenses that young adults find themselves in trouble for. So I'm going to cover operating a motor vehicle while intoxicated, and I'm going to discuss the penalties for the first offense, the second offense, the third offense, and the fourth offense. The crime of operating a motor vehicle while intoxicated is the operation of any motor vehicle, aircraft, watercraft, vessel, or other means of conveyance when any of the following conditions are present. The operator is under the influence of alcoholic beverages. The operator's blood alcohol concentration is 0.08 or more by weight based on grams of alcohol per 100 cubic centimeters of blood. So this is when the police officer at the scene would give you a breathalyzer. That would subsequently be followed up by a chemical test at a hospital. You do have the right to refuse to blow to give a breathalyzer. Now, however, you're going to learn that there is a situation where a person can be forced to blow. Even though they refuse to blow, they can be forced to consent to a chemical test. I'm going to cover that in detail more later. The operator is under the influence of any controlled dangerous substance listed in Schedule 1, Schedule 2, Schedule 3, and Schedule 4 and Schedule 5. So does controlled dangerous substance, the schedule that subsection C is referring to is the part of the law where all of the drugs that are considered illegal in the state of Louisiana, this is where you would find those drugs listed out. And the different drugs, and marijuana is in one class, meth maybe in another. So the schedule is comprehensive. It lists every drug, prescription and non-prescription, that it's illegal to consume without a prescription. Subsection D, the operator is under the influence of a combination of alcohol and one or more drugs that are not controlled dangerous substance and that are legally obtainable with a prescription. So oftentimes people will consume alcohol and they'll mix it with something else to give it a little bit more of a kick. That's extremely dangerous because you put yourself in a situation where you could be charged with a DUI even though you're technically under the legal limit. Subsection D2, it shall be an affirmative defense to any charge under this subparagraph that the label of the container of the prescription drug does not contain a warning against combining the medication with alcohol. So obviously if you have a prescription for any kind of pain medication, it typically warns you that it's not to be mixed with alcohol. Now, for some strange reason, if you receive a prescription that does not have this warning, you have a defense. It's an affirmative defense. You can hire a lawyer, show up in court and say, here's my pill bottle. I did not have a warning on it. I did not know that there would be any adverse effects by mixing this with alcohol. And that's a defense. That should put you in a great position to have those charges dismissed. Subsection E, the operator is under the influence of one or more drugs that are not controlled dangerous substances that are legally obtainable with a prescription. And you have the same affirmative defense. And look, even if you don't have a driver's license, you can still receive a DUI. A valid driver's license shall not be an element of the offense. So if you've never been licensed or you're driving with a suspended license, guess what? You can still be arrested and charged with a DUI. There's some additional provisions of that statute, but I'm not going to go through each and every one of them. the penalty statutes. So we just covered 1498, which is operating a vehicle while intoxicated. Now when we get to 1498.1, we begin to find out what the penalty is for each offense. And so what's the penalty for first offense DUI? The offender shall be fined not less than $300 nor more than $1,000 and shall be imprisoned for not less than 10 nor more than 6 months. But look, before we get there, we got to start here. It says, except as modified by paragraph 2 and 3 of this subsection on a conviction for a first offense. So if we read that, and we got to slow down, let's start by saying the minimum penalty here is $300. The maximum penalty is $1,000. The minimum jail sentence is 10 days. The maximum is 6 months. Now, if you look at this statute, it says and. So the fine and the jail time are mandatory. Whenever the law says shall, that means those provisions are mandatory. However, it's the law. There's always exceptions. So let's get to it. Subsection A serves 48 hours in jail, which shall not be suspended, or in lieu thereof perform no less than 32 hours of court-approved community service activities. At least half of it shall consist of participation in litter abatement or collection. So, the minimum penalty can be suspended. The 6 months that you're facing can be suspended. However, the law says 48 hours of those cannot be suspended. Now, obviously, there's an exception to the 48 hours. That gives you the option to negotiate a plea where you perform 32 hours of community service. At least half of it has to be done picking up trash, litter abatement. In addition to that, you have to participate in a court-approved substance abuse program. In addition to that, you have to participate in a court-approved driver improvement program. And look, the court can suspend your license or order you not to drive, because the DMV will suspend your license if you get arrested for a DUI. So subsection D, the court may order that the offender not operate a motor vehicle during the period of probation or such shorter time as set by the court unless any vehicle while being operated is equipped with a functioning ignition interlock device in compliance with this other statute. So the judge can either order you have a breathalyzer kit interlock device installed on the vehicle if you drive, or just prohibit you from driving for a period of time in general. I'm not going to cover the other statute. Part 2 deals with if your alcohol content is nearly double the legal limit, which is 0.08. This covers when it's 0.15. but less than 0.02. And all this does, if you have specific questions, you're welcome to ask me about it. But the basically, the drunker you are, the larger the penalty is. So I do want to cover this penalty. And it says, for first conviction, if the blood alcohol content is 0.15 or more, the driver's license of the offender shall be suspended for 2 years. So if you're nearly double the limit, you're looking at having your license suspended for up to 2 years. 1498.2, second offense. Remember, up to 6 months for the first offense. So let's recap. First offense. Fine of not less than $300, no more than $1,000. Imprisonment not less than 10 days, no more than 6 months. We've discussed exceptions that allow the 10 days to be reduced to 48 hours. All but 48 hours can be suspended. And we discussed that you have to participate in a court-approved substance abuse program, driver improvement program, and the court can order an interlock device put on your vehicle. So let's go to 1498.2. Penalties for second offense. The defendant shall be fined not less than $750 nor more than $1,000. So the minimum penalty financially goes from $300 to $750 when you get to second offense. The max penalty remains $1,000. The imprisonment shall be for not less than 30 days nor more than 6 months. So the minimum goes from 10 days to 30 on the second offense, and the max remains at 6 months. So we're still talking about a misdemeanor here. At least 48 hours shall be served without benefit, parole, probation, suspension. For the first offense, the judge can order this litter abatement and 32 hours of community service. Second offense, you got to do those 48 hours in jail. The judge can suspend the remaining of the time, but the offender is placed on probation with minimum conditions that include the following. So these are conditions by law. These are not discretionary on the judge. And here we go. Subsection A. Serve at least 15 days in jail without the benefit of parole, probation, or suspension of sentence, or in lieu of their perform 240 hours of court-approved community services. So that's your options. 15 days in jail, 240 hours of community service. Or B, you have to participate in a court-approved substance abuse program, just like you have to do for the first offense. Participate in court-approved driver improvement program, just like you have to do for a first offense. And as you can see, the court can order that you not operate a motor vehicle while on probation. And the court can order an ignition interlock device to remain in place, shall remain in place for not less than 6 months from the date of conviction. All right, so that's the penalties we're looking at for second offense DUI. And it increases if your alcohol content at the time of your arrest increases significantly based on the level of alcohol you may have had in your system at the time of your arrest. All right, so if the offender had a blood alcohol of 0.15 or more but less than 0.2, at least 96 hours of the sentence shall be served without benefit of parole, probation, or suspension of sentence. So there you have it. If it's a second offense DUI, 0.15 minimum blood alcohol content, 0.20 minimum blood alcohol content, you're looking at spending at least 96 hours in jail, and the court can suspend the rest. But here's the scariest part of all. The driver's license of the offender shall be suspended for 4 years. It's a long time to not be able to drive, especially if you have a family to provide for. So what happens if it's greater than 0.2? The offender shall be fined $1,000 and at least 96 hours in jail. Shall be served without benefit of parole, probation, or suspension of sentence. Here's additional penalties for that second offense. The court shall order not operate a vehicle while on probation unless it has an ignition interlock device. And look how long you have to keep it. The ignition interlock device shall remain installed and operative during the first 3 years of the 4-year period of the suspension of the driver's license. All right, here's an additional penalty if you get these DUIs back to back. That's right, Teresa Elmore, welcome. Don't drink and drive. I couldn't have said it any simpler than that. especially in today's world where we now have Uber, where you can just make a phone call. If you live in a little small country town, I'm sure there's somebody you can call who will come get you. So let's look at the subsection 4. We are under paragraph number 4. If the arrest for the second offense occurs within 1 year of the first offense, at least 30 days shall be served without probation, parole, or suspension of sentence. So look, if you get them back to back, you're going to be looking at a minimum of 30 days. You're taking yourself from 48 hours all the way up to 30 days. The judge can order home incarceration in lieu of jail, and you have to provide proof to DMV that you have the ignition interlock device installed on your vehicle. All right, here's some additional penalties that come into play if you receive a DUI after seriously hurting or killing someone. When the first offense was for a crime of vehicular homicide, third-degree feticide, first-degree negligent injuring, the offender shall be fined $2,000 and imprisoned without hard labor for not less than 1, nor more than 5 years. So this makes the second offense a felony. Any crime in Louisiana that carries a minimum of a year is considered a felony. So we're now talking about the second offense being enhanced. It gets enhanced anyway because the penalties go up and the minimum jail time goes up for the second one, even though the maximum jail time doesn't go up for the second one. If the first one was any of these enumerated crimes, vehicular homicide, feticide, negligent injuring, it's now a felony. That second one for you. Then it just goes through additional conditions you have to do. Probation with the minimum conditions, 240 hours of community service, court-approved substance abuse program, court-approved driver improvement program, home incarceration program for a minimum of 6 months, no more the remainder of the sentence of imprisonment. Just like for the first offense, the judge can order that you have an ignition interlock device. It shall remain in effect for not less than 6 months from the date of conviction. And the penalty is increased even more. The device shall remain installed and operative during any period that the offender's driver's license is suspended and for any other period determined by the court. So those, my friends, are the penalties for second offense, DUI. Third offense, 1498.3. The offender shall be fined $2,000 and shall be imprisoned with or without hard labor for not less than 1 nor more than 5 years. So the third offense, DUI, is automatically a felony grade offense. At least 1 year shall be served without benefit of parole, probation, or suspension of sentence. The mandatory minimum cannot be served on home incarceration. So you have to go to a jail or a prison for at least a year. But it's true with any other body of law or part of law. There's an exception. So let's talk about it. The 1 year may be suspended if the offender is accepted into a drug division probation program. Subsection 3, the court may suspend any or all part of the remainder of the sentence imposed If the court does suspend it, the offender shall be placed on supervised probation for not more than a period of 5 years, but not less than a period of time equal to the remainder of the sentence of imprisonment. The offender must comply both with the conditions of his release set by parole and with the conditions of probation of the sentencing court. So if somebody goes to jail and the judge gives instructions, if you get out, these are the conditions, and they make parole, and the parole board gives similar conditions or different conditions or additional conditions, you have to comply with all of them. You have to have an interlock device, just like you have to do for the first and second offense. And then for this third offense, the ignition interlock device shall remain installed until the offender has completed the requirements of substance abuse treatment and home incarceration, or if applicable, the requirements of the Drug Division Probation Program. Any offender convicted of a third offense shall, after 1 year, be required to provide proof to DMV that the motor vehicle being operated are equipped with functioning interlock devices in order to receive a driver's license. So once you get out of jail, serve your year, you got to do this. You got to get the ignition interlock device. Fourth offense, DUI. Regardless of whether the fourth offense occurred before or after an early conviction, the offender shall be fined $5,000 and imprisoned with or without hard labor for not less than 10 years nor more than 30 years. So when you get to this fourth offense, you're looking at a minimum of 10 years, a maximum of 30 years. Best thing you can do is not drink and drive. The second thing you can do is get yourself some help. If you've made it to your fourth DUI, you have a problem. 2 years of the sentence of imprisonment shall be imposed without benefit of parole, probation, or suspension of sentence. So as you know, lawyers, prosecutors typically get together and work out plea deals. The plea deals have to be accepted by the judge. Oftentimes there's limits to that, and the limits are prescribed by the legislature. And here's another example. 2 years of the sentence shall be imposed without benefit, parole, or suspension of sentence. That makes that mandatory. If there's an exception, we're going to get to it in a second, it's going to be contained in this statute. You see right here, the mandatory minimum of 2 years cannot be served through home incarceration. The 2 years shall be imposed without probation, parole, or suspension. May be suspended if the offender is accepted into a drug division program. So that's an exception. The 2 years, the mandatory 2 years can be suspended if you're accepted in a drug division program. Now notice I skipped over this part, except as prohibited in subsection B. So the 2 years can be suspended if you're in a drug division program, unless subsection B applies to you. So let's see what subsection B says. If the offender previously participated in a drug division probation program, 3 years of the sentence shall be imposed without benefit of parole, probation, or suspension of sentence. The offender shall not be eligible to have the mandatory portion of his sentence suspended because of participation in a drug division program. So you get one bite at this apple. If you are on your Fourth offense, we're on the fourth offense. If you were entered into the drug division probation program after your first, second, or third offense, you don't have that luxury when you get to your fourth offense. So you will have to do those 2 years. There's no exception. The court can suspend the remainder of the minimum 10, maximum 30, but they can't suspend that first 2. You're going to have to do that time. So that's all I'm going to cover with respect to DUI when we're talking about driving offenses. I do want to now talk about underage operating while intoxicated. Underage operating while intoxicated. Let's talk about that offense. The crime of underage operating a vehicle while intoxicated is the operating of any motor vehicle when the operator's blood alcohol content is 0.02 or more. An adult is 0.08 or more. A minor or somebody under the legal age of drinking is 0.02. So this is extremely low. The best thing you can do is, if you're underage, don't drink. And certainly if you do drink, don't drive. Because you'll likely be over the legal limits of 0.02. So here's the penalties for this underage drinking. First offense, first conviction, fine not less than $100 nor more than $250. In prison for not less than 10 days nor more than 3 months. Misdemeanor. The judge can't suspend a sentence unless you're placed on probation with these conditions: 32 hours of community service, court-approved substance abuse, driver improvement program. On the second conviction, fine not less than $250 nor more than $500. In prison for not less than 30 days nor more than 6 months. Still a misdemeanor, but the minimum and the maximum time have gone up for the second offense. You can be placed on probation. However, you got to spend 48 hours in jail. If the judge doesn't want to put you in jail, 80 hours of community service in lieu of those 48 hours in jail. You still got to do these programs: court-approved substance abuse, court-approved driver improvement. You can't get home incarceration, and the court can order you not operate a vehicle unless you have a functioning ignition interlock device. And that pretty much sums up the statute governing underage drinking and driving, or DUI and driving. I know we've all heard that you should not submit to a breathalyzer test or a field sobriety test, and I stand by that. You should not submit to those. You're not required to by law. However, I want to talk about an exception. If this applies to you, you have to submit. Unlawful refusal to submit to chemical tests. Arrest for driving while intoxicated. So listen carefully. No person under arrest, those are the drinking statutes, may refuse to submit to a chemical test when requested to do so by law enforcement if he has refused to submit to such tests on 2 previous and separate occasions. So if you've been stopped for DUI twice, refused to submit twice, you won't get to do it a third time. The third time, you no longer have this option. And let's talk about the penalties. Whoever violates, fine not less than $300 nor more than $1,000. In prison for not less than 10 days nor more than 6 months. The judge doesn't have to put you in jail. He can put you on probation. Minimum conditions that he serve 2 days in jail and participate in a court-approved substance abuse program and court-approved driver improvement program. You will have to do 32 hours of community service. At least half will be picking up trash, litter abatement. And look, if you get hurt doing litter abatement, you can't sue the entity conducting the program or supervising your participation. So if they throw you out there and I guess you get hit by a car while on the side of the road picking up trash, this statute would seem to suggest you can't sue the agency. You can obviously sue the driver of that vehicle, but the agency involved, it looks like they're protected by law. I want to move on and talk about a few other driving offenses that young adults often commit. The next one is reckless operation of a vehicle. What is it? Reckless operation of a vehicle is the operation of any motor vehicle, aircraft, or vessel or other means of conveyance in a criminally negligent and reckless manner. So if you're speeding down, drag racing, speeding, driving on a vehicle that's made for the highway, off the road, weaving in and out of traffic, speeding excessively, you can be charged with reckless operation of a vehicle. And here's the penalty. Whoever commits the crime of reckless operation shall be fined not more than $200 and imprisoned for not more than 90 days or both. On a second offense, fine not less than $25 nor more than $500 and imprisoned for up to 6 months. The best thing you can do is simply not drive reckless. There's no need to do that ever, really. And if you want to have some adventure, get you an off-road vehicle, get you a four-wheeler, go ride a four-wheeler, get you a jet ski, go ride a jet ski. But just don't do it on the roads that are shared by everybody else that's trying to, make it home safely to their families. Reckless operation of a vehicle is something that should never happen. And then this applies to sober people. So obviously if you're sober and you're driving reckless, you shouldn't be doing it. The last one I want to cover is hit and run driving. Now, people think this is minor, but when we go through this statute, you're going to realize that you can be looking at some serious time for hit and run driving. So let's get right to it. Louisiana Revised Statute, Title 14, 100, hit and run driving. Hit and run driving is the intentional failure of the driver of a vehicle involved in or causing an accident to stop such vehicle at the scene, give his identity, and render reasonable aid. And it even tells you what give his identity means. The driver involved shall give name, address, license number of his vehicle, or shall report the accident to police. It defines what accident is if you don't know. Any incident or event resulting in damage to property or injury to person. Then paragraph C covers the penalties. So let's talk about those. Whoever commits the crime of hit and run driving where there is no death or serious bodily injury shall be fined not more than $500 or imprisoned for not more than 6 months or both. So you're looking at $500, max fine, 6 months, max jail sentence. Here's an additional penalty under subsection B. Whoever commits the crime of hit and run driving where there is no death or serious bodily injury shall be fined not more than $500 or imprisoned for not less than 10 days, no more than 6 months when the 3 additional conditions are met. So this is a more severe punishment. The penalty goes from no minimum jail time to a minimum now of 10 days, and the max still remains 6 months. The fine doesn't change, but here are the 3 conditions. If you're involved in a hit and run and these 3 elements are present, you're going to be looking at a minimum of 10 days in jail. There's evidence that the vehicle operator consumed alcohol or used drugs. The use of alcohol or drugs contributed to the accident. The driver failed to stop and give his identity or render aid with the knowledge that his actions could affect an actual or potential present, past, or future criminal investigation or proceeding. So these 3 elements, alcohol in your system, these 3 elements will have you looking at 10 days to 6 months. Your minimum jail time will become 10 days if these 3 elements are present. Alcohol in your system, alcohol or drugs. The alcohol or drugs contributed to the accident, and you failed to stop and give your identity, knowing this information was important to law enforcement. Let's go back to the statute now. Whoever commits the crime of hit and run driving when death or serious bodily injury is the direct result of the accident shall be fined not more than $5,000 and imprisoned with or without hard labor for not more than 10 years or both. So your fine goes from $500 to $5,000, up to $5,000 if somebody dies as a result of your hit and run. And your jail time goes from 0 to 6 months or 10 days to 6 months, depending on the situation, to up to 10 years in jail. And then here's an additional penalty. If whoever commits the crime of hit and run driving where all of the following conditions are met shall be imprisoned with or without hard labor for not less than 5 nor more than 20 years. Death or serious bodily injury. The driver knew or must have known the vehicle was involved in an accident. The driver has a prior conviction for any of the following. And these are the drinking and driving statutes. This is vehicular homicide. This is vehicular negligent injury and first degree vehicular negligent injury. So if you have a previous conviction of any of the 4, DUI, DWI, vehicular homicide, vehicular negligent injury, first degree vehicular negligent injury, your minimum jumps from a minimum of 5, a max of 20. Without prior convictions for any of those 4, you're looking at no minimum jail time, but a maximum of 10 years. And now, if you have the prior convictions for any of the items we just discussed, you're looking at 5 to 20. So I'll say all that to say, hit and run driving is dangerous, it's serious, and it can land you in prison for up to 20 years. I know it sounds unreal, but if you're involved in a wreck like this and somebody dies and you have a prior conviction, you're looking at up to 20. If you don't have a prior conviction and there's a death, you're looking at up to 10 years in jail or prison, whatever the court decides.